Magandang hapon po sa inyong lahat, mga law students, bar reviewees, at mga interesado na malaman ang mga current issues. Ito po ay legal forum on current events at ito po ang umpisa ng aking free lecture on how to study and prepare for the bar, especially now that our lockdown will continue until the end of this month, September. So for my students in University of Manila School of Law and Philippine Christian University and other review centers. Ito po ay sa aking pagnanasang maibahagi sa inyo kung papaano ang pag-aaral at paghahanda sa bar exam. Bar review starts at first year in the law school because the bar is principally a test of your knowledge of the law, logical reasoning, and good legal writing, brief and direct to the point, with cohesion and without redundancy. Ang una kong advice sa kumukuha ng law, sa first year pa lang, paghandaan na ninyo ang bar exam. Dahil ang bar exam, ang bar will largely depend on your stock knowledge of the law. So as you start in law school, you start restoring adequate knowledge of the law. Ang unang-unang dapat ninyong gawin sa paghahanda ninyo sa examination sa law school ay inyong basahin ang lahat ng mga previous bar questions. Noong ako'y first year sa law school sa UP, College of Law, binasa ko lahat simula sa umpisa ng bar exams, 1902, dito sa Pilipinas. Binasa ko lahat yan. Total, mayroon namang publication ang Law Center, bagay diyan, at ang latest na exam sa bar ay sinasagot ng UP Law Center at ng Association of Dean Law Schools. The advantage of familiarizing yourselves with the previous bar questions is you are able to identify the recurrent important principles usually asked in the bar. At makakapag-concentrate kayo habang kayo ay naghahanda sa inyong prelim, midterm, final exam sa law school. Inyong tingnan ang madalas itanong sa bar. At ang ginagawa ko, hindi pa ako professor noon, nung ako'y nag-aaral, hindi katulad nung iba na nakapagturo na agad. Ang ginagawa ko ay, if I were in the place of the professor, what would be my questions? At kung sakali naman na take home, kamukha ng mga problem. For example, in the tradition of the Socratic method in the UP College of Law, which has been adopted in Ateneo and in other law schools, you are required to view the issues from both sides. Take the case for the plaintiff, then for the defendant, and then you are required to resolve the issues with reasons raised by both sides. Kapag ka ang question na ibinigay sa akin nung ako'y nag-aaral pa ay take home, ina-anticipate ko lahat na pwedeng itanong at meron akong ready answer. So much so that when I was graduating in the UP School of Economics, our professor was a visiting professor from Harvard Business School. I remember Professor Guillermo, and he gave us a take-home exam. Draw a comprehensive economic plan for the Philippines. I anticipated that that question would be asked, so I prepared my answer, complete with footnotes from United Nations documents. I got a perfect score in that subject on development economics at the UP School of Economics. Now, during the lectures, when you are already reviewing for the bar, and even for those who are just studying law, I would advise you to outline in each separate notebook all the core subjects in the bar. I call this elements notebook, and I require this in handling review classes in Ateneo, UP, and in all the downtown law schools where I taught review subjects. The advantage of making an outline in your own words is that what you have written down is something that your subconscious mind will never forget. The best kind of knowledge is subconscious knowledge. You don't even have to think about it. It becomes second nature to you. And if you are sufficiently interested in a subject, mastery is not far behind of the issues, the pros and cons. Now, the element notebook is very important during the pre-week because practically you do not have any time to be reading, going back to all the voluminous materials. You can just rely on your outline. And I require this to all my bar reviewees to have an outline, what I call an elements notebook in each subject. In summary form, the elements of each subject, particularly in criminal law, which is the most difficult question in the most difficult subject in the bar. Why? Because the answer is exact. And if you know all the elements, with one element missing, then your answer is no, and then you state that missing element. You don't have to repeat what are the other elements that may be present because you are in a hurry. The bar nowadays are very, very long. Listen and take down notes during the lectures, both in law school and in the pre-bar, because by taking down notes, you reinforce your power memory. What you have written is something that is etched in your subconscious memory. And so, when the time comes that you are called upon by any problem in the bar, then it comes out of your memory. The mind is better than a computer because even while you are sleeping, it continues to work in the reverie stage of thinking. Now, particularly if your professor is making an integration, correlation, and assimilation of related principles of law. Because in law practice, you should learn to have a creative imagination, because not all problem has an exact solution in the provisions of law. You have to innovate, and you have to adapt arguments by analogy. One example which I One example is a case that I won in a criminal case for estafa. My client was a secretary of a director, representative of a foreign bank, and she was authorized to withdraw checks. She was accused of forgery or falsification of commercial documents, because a check is a commercial document. I could not get any documents from the bank because we were refused access. So what I did was to file a labor case and argue that there was violation of due process because my client was not afforded an investigation. The counsel for the criminal case was different from the counsel in the labor case. And as a defense in the labor case, the investigation report was submitted, and I saw there that the common defense of the tellers and the branch manager who were investigated was that the withdrawals were authorized, because there was a small note authorizing my client to encash the check. So applying the law on trust and Article 23 of the Negotiable Instruments Law, which provides when a signature is forged or made without the authority of the person whose signature it purports to be, it is null and void. And you cannot get a discharge of the check or instrument except where there is estoppel. I am just making a summary of the law. Now, so the cross-examination was very simple. Just three to five questions from each witness from the bank, the teller and the branch manager. So when I confronted them with a copy of the authorization, my opposing counsel was very, very alarmed and shocked. And he thought that I vulgarized the bank. But anyway, since criminal case requires proof beyond reasonable doubt, all you need to do as a defense counsel is to create doubt. And based on reasonable doubt, you are entitled to an acquittal because of the presumption of innocence that must be hurdled by proof beyond reasonable doubt. My next advice is keep abreast with contemporary legal events. These are fertile source of bar examinations, because the current unresolved issues are usually taken up in the bar. And also leading cases, novel precedent-setting cases are usually asked in the bar. And even cases that are still pending. An example is whether the President may unilaterally withdraw from the visiting forces agreement or from the accession or membership to the International Criminal Court without the concurrence of 2/3 of all the members of the Senate, which is required for the ratification of treaty by the President. The issue is still pending in the Supreme Court, and if I were to be an examiner in political law and public international law, I'm going to ask this. And you can answer this either way and be correct. Because in international law, there are two conflicting precedents. In the United States, when General Carter abrogated the Treaty of Friendship and Defense with Taiwan, the U.S. Supreme Court declined to assume jurisdiction. Foreign relations, as held by U.S. and Philippine Supreme Court, is a political question. It is a question that is left to the discretion of the President, who is responsible only to the people in suffrage. In the Philippines, when Gloria Macapagal Arroyo refused to ratify the Rome Statute, which created the International Criminal Court, Pimentel filed a mandamus case against the Executive Secretary. And the ruling of the Supreme Court is that we cannot compel the President to send to the Senate for concurrence to ratify the Rome Statute. So what happened was that it was held to be a political question. Conduct of foreign relations by the President is a political question. Now, there are two kinds of political question. One is where the discretionary authority is lodged with another department of government. Then it is a political question that cannot be interfered with. The discretionary authority cannot be interfered with by the Supreme Court. However, where the acts of either the legislative or the executive or their instrumentalities and agencies are tainted with grave abuse of discretion, this is tantamount to lack or excess of jurisdiction. And under Section 1, Article 8 of the Philippine Constitution, the Supreme Court may step in and as guardian of constitutional processes, review and nullify acts that are in excess of jurisdiction or with grave abuse of discretion. Now, grave abuse of discretion is an arbitrary act, unreasonable, whimsical, and capricious, as compared to error in judgment, which is correctable by appeal. Now, grave abuse of discretion is correctable by certiorari under Rule 65 and under Section 1, Rule 13. The other precedent came from the Supreme Court of the South Africa, where the Supreme Court held that unilateral withdrawal of the President of South Africa from the International Criminal Court is null and void because it is without the concurrence of 2/3 of all the members of the Senate. So you have two precedents, pros and cons, on the issue that is pending in the Supreme Court, because the abrogation or withdrawal unilaterally without the concurrence of the Senate is now pending in the Supreme Court on a petition for certiorari filed by some senators. Now, so if you are required to argue for the Solicitor General, then you can cite the ruling of the Supreme Court of the United States in the Carter case. Now, if you are asked to argue for the senators, then you can cite the decision of the Supreme Court of South Africa. Now, if you are required to resolve the issue, then you can use the political question doctrine and say that it is beyond the review and interference of the Supreme Court because it is a political question. Now, other issues that are likely to be asked are the recent issues, which I call leading decisions of the Supreme Court. And in the most recent case, on the issue of whether a tipped information is sufficient as basis for a determination by the police of probable cause to conduct reasonable arrest without warrant, searches and seizures. And there is a diversity, two lines of decisions emanating from the same Supreme Court, which have been reconciled by this case. And the final ruling is a tipped information alone and by itself, without personal knowledge of facts and circumstances that would engender a reasonable belief that the crime has been committed and the author is probably the author of the crime, without these confirmatory facts and circumstances, searches and seizures without warrant based on tip information from an informer is not sufficient. There should be facts and circumstances of personal knowledge by the police. An example is hearsay evidence sufficient? The answer is yes, because in one case, there was a robbery. The police officer responded, and the victim, the owner of the apartment that was robbed, gave a description of the robber and point to a place where the robber escaped. True enough, the robber was apprehended, and the question is whether hearsay evidence is sufficient. Now, in this case, the Supreme Court sustained warrantless arrest because there are facts and circumstances known personally to the police, such as the information given to the police personally. Now, in the Sapla case, it was a tipped information made by an identified informer. However, there is a dissenting opinion which I agree to. And the reason is this. There was an unidentified informer who called the station, and then there was another call saying that the culprit already boarded the jeep, and his appearance, even the clothing and the bag in which the marijuana was loaded was described. And so in 20 minutes, a checkpoint was set up and an arrest was made. Now, in some other decisions that were abandoned by the Sapla decision, this would have been sufficient, because in the constellation of constitutional values, the police power, the right to apprehend pushers, to my mind, carries a higher value than limitation on the right of citizen. And that was the deciding opinion of Justice Mario Lopez. He was my co-reviewer in the late bar review of Dean Romualdez in criminal law, and he also served as a judge in my hometown in San Jose, Batangas. I believe that he deserves to be the next Chief Justice of the Philippines based on his ability. Now, other issues that should be given attention to is what is happening in South China Sea. Secretary Locsin said we should not bring it to the International Court of Justice, because we should not relitigate what we have already won. And his opinion is that we should solicit and harness the support of all the freedom-loving countries of the world, particularly those who have a stake with similar exclusive economic sovereign right in the South China Sea, like Vietnam, Japan, Indonesia, Taiwan, because the decision is very clear that under the UNCLOS, the 9-line theory of China has no historical support. And I have reviewed the literature for China and also for the Philippines. Now, for the Philippines, the research we owe to Justice Tony Carpio, who was able to unearth the Treaty of Washington, rectifying the mistake in the definition of Philippine territory in the Philippine Bill, in in the Treaty of Paris of 1888, whereby the Spain ceded to the U.S. the treaty, the entire Philippines at $2 per Filipino. It was a mistake that was not clarified, and I was wondering why even historians in books taught in law school and even professors did not know the amendatory treaty of Washington of 1900 that rectified and included in the definition of Philippine territory the Scarborough and the other islands in which we are entitled to sovereign ECC rights and continental shelf rights under the UNCLOS. Anyway, even if the issue is litigated, there is a finding by British researchers that the historical claim of China is only of modern origin. There was no ancient support in their claim, and that was published worldwide in a seminar on the issue. But anyway, students are well advised to study the issues in the South China Sea, and particularly get the definitions of what is an island, that it is capable of sustaining life, in order to be entitled not only to economic seas territory, but also to exclusive economic zones and to continental shelf. Another issue that is pending in the Supreme Court is the constitutionality of the anti-terrorism law of 2020. Now, I will not discuss that issue anymore here for lack of time. You just read my blog, also in Legal Forum on Current Events, the article I posted entitled "In Defense of the Anti-Terrorism Law," where I said that based on the decision of the Supreme Court in David versus GMA, a law that is valid on its face cannot be invalidated simply because it is susceptible to abuse in the implementation. Now, for law students, you brush up on English grammar and composition because it is an unwritten rule in the bar that English grammar is included. Now, I remember when I was in the United States as MCLE lecturer, together with my wife, Sheni, the examiner in legal ethics flunked more than 80%, in fact 82%, and passed only 18. And I said, why is that? And she said, because I do not want lawyers who do not know good English. But I said, but English, it's not a test on English. Yeah, but the test also is to see the facility of expression. So I would advise law students and bar reviewees, please brush up on the English grammar and make sure you have uniformity in tenses, in numbers, and also make sure that you write directly, you answer directly and to the point, briefly, either using the inductive or deductive analysis. That is, put up the premise first and then the conclusion, or answer directly and then give your reasons. The more reasons, the better, particularly for questions with more points. And I would advise even students and even lawyers to get a copy of the Elements of Style of William Strunk. I got this when I was already a lawyer at CSIP Salazar, and it has tremendously improved my ability to write pleadings. Law requires diligence, focus, and hard work, both in the study in law school and in the practice of law. The study of the law must be coupled with passion. It should be a labor of love, dedication, and respect for the rule of law to secure justice and equity to our fellow men. It requires courage to stand up for what is right. And in the tradition of my law fraternity, to keep right when right, to set right when wrong, and to fight, right or wrong, fight. Because a brilliant mind is useless without a fighting heart. I will elaborate on this and give updates on current issues and a discussion of the burning issues of the day that might be taken up in the bar when I give my lecture, and everybody is invited, to be sponsored by the Scintilla Juris Fraternity Zamboanga branch or chapter that is tentatively scheduled on September 12 in the afternoon. The format will be prepared by them, and I am even willing in that webinar to answer questions during the webinar. And so please watch out for announcement by Premiserius Banson on the format and on the online seminar. And it is planned to be a series for updates on law and jurisprudence, as I have already started in my legal forum on current events, and also a continuing lectures in the bar, maybe mock bar with questions and answers, and also on the updates And I plan to give an overview of all the subjects in the bar as I have been doing in law school as study guide. And I have a book. It's called Study Guide for the Bar, where I have a chapter on various kinds of thinking, because actually reading and listening are only means of acquiring knowledge. And you impart knowledge by writing and by talking. And so I have in my study guide for the bar a chapter on speed reading, a chapter on the art of taking down notes, the art of listening, and brief instructions on elementary rules of grammar and English composition. And I will try as I go along in my pre-lectures on how to study and prepare for the bar, explain some more on these techniques on how to prepare for the bar. Thank you. Until next time.